Welcome, everyone. We're going to get started. I am so pleased to see all these people in the room. This has been the culmination of many months of hard work, and we are just so excited to see you all here. I'm going to start just with a little bit of a story. I'm LaToya Baldwin-Clark. I am the faculty director of the Critical Race. So let me just start a little bit about my connection to CRS. So I arrived here in 2018. I learned about CRT in law school, and as a sociologist, thinking structurally about schools and race and parents, critical race theory was very, very attractive to me, both as a methodology and also the substantive focus that motivated my own work. As I made my way through the job market, I was absolutely thrilled that these wonderful faculty at CRS wanted me as much as I wanted them. I had learned so much from them over the years, and I knew I was coming here as soon as I got the offer, and also because the weather was really, really nice. So 8 years later, I am still here, and I'm as thrilled today as I was the first day that I got here. This is my intellectual home, and being faculty director to this amazing program over the last 3 years has given me a purpose, unlike any other, which is to usher this program through to where we are today to celebrate 25 years of the preeminent CRS program. It's hard to believe that it's been 25 years. From its founding, we've graduated hundreds of students and launched the academic careers of many people who are in this room. We are a crucial part of the UCLA law community and UCLA as a whole. Many of our founding faculty are still here, and we're also gathering faculty that are no longer here in the building, but that are CRSers for life. Now, of course, this moment of celebration occurs during a time of gross violations in international law in the form of genocides in Gaza and the Sudan, aggressive invasions in Eastern Europe, global violations of democratic norms and processes, the dismantling of even modest DEI programs, the elimination of affirmative action, the likely evisceration of voting rights, the rolling back of disability protections, and explicit racial profiling in immigration, not to be a downer. We're also gathering now in Trump's second term and witnessing what might be the pinnacle of retrenchment of the last 20 years. Like the redemption of Jim Crow that came after Reconstruction, this administration's term seeks not only to stall gains towards racial equity, but to literally turn them around and usher in an era to make this country great for white supremacy. It is not an exaggeration to call this time a second redemption, where the march towards authoritarianism has been quick and destabilizing. This program, CRS, was born at a time of crisis after the passage of Prop 209 that ended affirmative action in California, and it confronts a crisis again today. Our program's motto, and also for the Symposium, is Think, Teach, Transform. Our program is anchored by my brilliant colleagues working in the critical lens of CRT, establishing us as thought leaders in our various fields. We teach. The Critical Race Studies program and specialization challenges our students intellectually, where they must learn CRT, civil rights, and also take practical courses that seriously interrogate racial consciousness. And as you'll see in our program, our students and our graduates are transforming their communities and other institutions using the tools that they learn here. Thus, for these next few days, we will not only celebrate, but come together as a community of critical scholars, activists, and advocates to recommit to the liberatory promise of critical race theory. Now, just let me say a few words about the next 2 days. We'll have 3 plenaries that are organized around these themes of think, teach, and transform. After this intro, we'll start with our first plenary that hears from scholars associated with our program to simply set the tone for the rest of the symposium. Our second plenary will talk about and discuss innovations in teaching race consciousness in law schools. And the third will focus on transformation, how CRT is actually being used to transform communities. The heart of our program, though, are the 20-plus panels that push the boundaries of CRT, that use CRT in other areas, and that show us how CRT is used in racial justice work. So we're also here to celebrate all of you who are carrying this work forward. Let me take a few minutes just to thank some of our sponsors. I want to thank UCLA Law's Williams Institute, the Emmett Institute on Climate Change and the Environment, Nicole Gambino, a UCLA alum of 2026, the law firm Corey, Luzak, Degati, and Riddle, LLP, and the many others who gave money, time, and experience to making this happen, including our dean, who you'll hear from tomorrow. And though I know they don't want me to do this, I'm going to do it anyway. Especially thanks to Jasleen Coley, our executive director. And Ida Hagigoku, did I say it right? Almost. Our program coordinator extraordinaire, who really has made this program very possible. I also want to thank the steering committee that helped put this program on. And I want to thank you for coming, for being with us for the next several days. If you need anything, don't hesitate to ask Jasleen or Ida. So we're going to get started with our panel just right away. How about I'll just do kind of brief introductions from here, and then I'll go get up there, and we'll start answering our questions. Now, I won't be doing full biographies. You'll be able to find the biography of all of our panelists, including our concurrent panelists, on our online program. But today we have Cheryl Harris as the Rosalind and Albert Gilbert Foundation Chair in Civil Rights and Civil Liberties, and a founding faculty member of the CRS program. We have Tendai Achiume, who is now professor of law at Stanford University, but she will always be us. We have Emmanuel Molion, who is an associate professor of law at the University of Minnesota and was the Bernard A. and Lenore S. Greenberg Teaching Fellow, which was housed in collaboration with us, CRS, and the Williams Institute. And Kesu Park, who is a professor of law, who was also a critical race studies fellow here at the law school, and who has returned to us, returned back home. Thank you. So we're going to start our program again with setting the tone here. And I'm just going to ask our panelists a few questions, giving them a little bit of time to kind of talk to you about why we're here and why this is so important. So I am going to start with Professor Harris. And I'm wondering if you could just briefly talk about kind of the instantiation of the program, but also why you think this program is still so critical at this moment.
Thank you. I'm really, really honored to be here. It's striking to me that it's 25 years. It's improbable that we are here together. The program was improbable from the beginning, and the fact that we are here is important to me because none of this is preordained or guaranteed. We come from struggle. We come through the fire. We descend from those who were brought here in chains or were pushed out or starved out or driven out or targeted to be wiped out or dispossessed. But we're here, and I really just want to talk to you today about how much I think it's meaningful that we are here in collaboration, thinking together as part of a program that was improbable from its beginning. I mean, there's a lot to consider, but I want to, I guess, say a few words. I wrote an essay about the founding of CRS 2 years after it was founded in 2000, and I was looking back over 2 years at the time. But one of the things that was very clear to me then was that, as LaToya just mentioned, the program, very much like CRT itself, the body of work on which it was founded, arose from a period of very intense political struggle. And that struggle was happening both inside and outside the academy. Like CRT itself, which emerged in the late 80s and early 90s, these fights were about the meaning, the sources, and significance of race and racism, and the role of law and legal institutions in its constructions. It was basically, the field had been previously defined by a kind of liberal legal regime which centered on the idea of eliminating explicit manifestations of racial hierarchy through the system, through the implementation of a certain conception of anti-discrimination law. Conservatives, on the other hand, opposed these reforms and any reading of anti-discrimination law that required more than conferring formal equality meaning we're only attacking those explicit uses of race that are subordinating. And the conservatives asserted that any attention to structural inequality was too much. So any conversation about disparate impact, any conversation about affirmative action, all of these were considered to be too far. So that was kind of the way the field was defined. And the field of race and law more broadly, or civil rights law. And so this battle was not only playing out, however, in the academy and in educational institutions like Harvard or here at Berkeley or UCLA. These were fights in these institutions over admissions and questions like hiring, but it was also happening in the broader political arena. So liberals were arguing that affirmative action could be justified as a kind of necessary, temporary exception to otherwise colorblind, neutral procedures. And conservatives were arguing the opposite. The conservative position was on the ascent. They were accruing state power and influence. The judiciary was changing. And so the liberal reform position was under siege. CRT's intervention in this debate, however, was to point out that both the liberal and conservative vision was predicated on the same erroneous premise. That is that the existing system was governed by objectivity, neutrality, and merit, and was colorblind. That both liberals and conservatives agreed around that premise, they just disagreed over whether or not an exception was justified. The fact that law across every domain had played a crucial role in constructing racial power was largely ignored in the debate. And CRT's commitment then was to develop a theoretical approach and an analysis that would remap the legal terrain, expose the limitations of the prevailing colorblind racial ideology, and facilitate its disruption. By the early 2000s then, when UCLA and UCLA Law School had become ground zero for these debates, 1995, when I first arrived, and I'm looking now for the student that met me at my office, the then student, there he is. That would be Saul Sarabia. Had become ground zero for these debates, and the regents had just adopted a resolution precluding any consideration or any school from using race, religion, ethnicity, sex as a criteria for admission, followed on the heels by the Proposition 209, which was adopted in 1996, which banned so-called preferential treatment on the basis of race and sex. The problem that we encountered was that the school, upon the amendment of the state constitution and the adoption of 209, was faced with the task of changing its admissions policy. And one of the things is that it became very clear, particularly through the students and the students' activism, which I want to stress was key to the creation of this program. It was clear that Proposition 209 might have banned preferential treatment, but it did not mandate a particular LSAT median or GPA. Those were institutional decisions that were still within the power of the institution, and there were institutional decisions that the school was making that were not demonstrably tied to who would be a good lawyer. And in fact, it was treating the school like a black box in which students' academic performance was strictly a consequence of their prior grades and test scores, as though what happened to them in the institution had nothing to do or was of little consequence in terms of their performance at all. So after several student activist actions and protests, it became very clear that CRT had a lot to say to this situation. And the critical theory was articulating what the ground was that we were actually struggling on. Because the students were experiencing, as we were, the consequences of a policy that was premised on a colorblind conception, a theory about race that was profoundly wrong about how race functions. To put it another way, while 209 claimed that eliminating race-conscious admissions would eliminate the stigma of affirmative action, making race less significant, and making the school experience better for all students, for black and brown students at the school, the opposite was true. Being the only black or Latino in a classroom was not empowering, nor did it make race any less salient. This fight really reflected and incorporated the racial politics in the broader society as the relentless pursuit of colorblindness and policy inside the university carried over into the broader policy at the state level with Proposition 209, which became the predicate for similar propositions in other states, and in the courts to basically justify increasingly narrow constructions of anti-discrimination law. So there was a lot of debate at the time about whether or not affirmative action was actually something that was hard to defend. I heard liberals make this argument. Maybe this is something that we need to just concede because we have other ground that we need to fight. What this whole argument missed was that they were beta testing the arguments in affirmative action that eventually became rolled out in every other domain. K-12 education, parents involved in community schools, voting rights, Shelby County, employment law, Ricci versus New Haven. All of these were places where the same arguments that had been mobilized against affirmative action were mobilized against the very foundational structure of anti-discrimination law itself. And so what we were trying to say at the time is that the idea that attending to race was a form of racism, this colorblind theory of race, was masking and obscuring racial power not only in anti-discrimination law, but in other areas that had traditionally not been considered the subject of race and law questions, like policing, immigration, or family law. Thus, the massive inequality in the operation of these key areas was often simply noted as a footnote, or either not noted at all, and the collective effect of this erasure was to update and heighten the racial exception to the rule of law. This is something I've been trying to think about, the ways in which what we have here is a system where the exceptions have been foundational in the Constitution and in other founding documents. That is, you have a system in which the law, the rule of law, the idea that no man is above the law, that the law applies equally, the rule of law actually has racial exceptions carved into it. Right from the outset, they are challenged by struggle and reform, and then they are appear again. This is Kimberlé Crenshaw and retrenchment. But what we see in this sort of reinstantiation, I've been thinking about this as a historical kind of process. These racial exceptions get reframed through courts and politics, as Latoya just talked about now in the moment of the second redemption. We have a return again to this question. My point in giving this history was to say, and I wanted to actually give a little bit more explicit history, but I don't want to take up too much time. The consequences of the implementation of 209 were immediate and catastrophic here. So when I arrived in 1995-96, there were approximately 90 black students in the law school and over 125 Latino students, more or less. And by 2000, when the program was founded, the class of 2002 had 2 black students in it. and about 13 Latino students. There were also significant decimations of the populations of some Southeast Asian students, particularly Filipinos. And so we went from a situation where it was the most racially diverse law school in the top 20 to one where by the following year, there were, I believe, fewer than 20 students, black students, in the entire school. And that experience was one which, again, brought to ground what the consequences of colorblind ideology and theory actually were. I've only got a few more minutes, so I want to talk a little bit about today. So what is the relevance of this history today, and what does the moment require? Well, there is an importance of memory and the crucial power of history and a renewed commitment to theory and practice. There's a daunting list of troubles which LaToya gave us. We could go on. We are in a period of what I believe Antonio Gramsci in the late 1920s famously called the interregnum. The crisis, he says, consists precisely in the fact that the old is dying and the new cannot be born. In this interregnum, a host of morbid symptoms appear. What are we in but a set of morbid symptoms? Like the loss of legitimacy of institutions, like the concentration of power to rule by force, like the turn to fascism. I know there are many debates inside and outside the academy about whether or not the U.S. political regime can now be called fascist. I'm not a scholar of fascism, but I think we probably all should become such. To be clear, however, the notion that the U.S. has only now had fascist tendencies would be a mistake, in my view. As black historians, theorists, and writers going back to Du Bois long noted, the fascism that showed up in Europe, in Italy, and Germany had its predecessors in the U.S. Indeed, Langston Hughes wrote in 1937, "We Negroes do not have to be told what fascism is in action, we know. Its theories of Nordic supremacy and economic suppression have long been realities to us." The paradox is that while this violence is ongoing and increasing, some of us can still function in our daily lives as though it does not exist. This creates what Ketanji Brown Jackson wrote in her powerful dissent in the birthright citizenship cases, which I encourage you to read. She described this as a zone of lawlessness in which the majority has authorized that which will disproportionately impact the poor, the uneducated, and the unpopular, and I would add to her list, and those that are not white. So once again, we have the racial exception to the rule of law. It's arguably an instantiation of what writers have called the dual state, which was used to describe Nazi Germany, in which there's a lawless zone applicable to the disfavored that coexist with a legal regime governing the ordinary processes of commerce and other social relations in which most Germans were living. So you have basically a kind of two-state situation, a dual state situation in which one group is living under lawlessness conditions and the other is living, they're going to the store, they're buying toothpaste. I highly recommend an article on this by Pima Levy and Mother Jones. All of this, I think, argues for the importance of history, not because history will exactly repeat itself, but because it can provide greater clarity in the present. And finally, on the role of theory and practice in spaces like CRS, what is their role and significance? Well, I don't think we can anticipate a resolution of these problems in the interregnum. As Cedric Robinson, author of Black Marxism and a theorist of racial capitalism, once said, racial regimes are often ramshackle. I'd say ramshackle. He says, they are makeshift patchwork masquerading as memories and the immutable. It's important to remember that this is ramshackle. It is full of contradictions. The idea that it is powerful sometimes makes us think it is not unstable, but it is highly unstable. And it's in that instability that I think there is an opportunity for our interventions. Hegemony always has to contend with resistance, as well as with its own internal contradictions. And we can see this now in a number of ways. In this moment, where the zone is being flooded with shit, it's important to understand that the legal scaffolding here is not invincible or even governed by logic. And as we move through this period, it's calling not for less theory, but more, combined with and emerging from practice. As we move through this period where the old is dying and the new is not yet born, we can remember our history as a prelude to imagining, theorizing, and dreaming an impossible future. Thank you.
Thank you so much. I want to now turn it to Professor Achiume. You were a founding faculty member of our Promise Institute for Human Rights. And I'm wondering if you could talk about the work that you've done and why the institutional space of CRS was so important to get that work done.
Thank you so much, LaToya, and thank you everybody for being here. Thank you for the panelists for being here. I'm not even going to apologize or say something self-deprecating about going after Cheryl Harris because it is the privilege of my life to constantly be surrounded by people who are smarter than me, and I feel like it is the best thing you can do to surround yourself with people who are this amazing. So I'm thrilled to go after you, Cheryl. Okay, so I think of myself as in the born free category. This is a term that I don't think many people may be familiar with here, but if you grew up in Southern Africa and in Zimbabwe, those of us who were born after independence from colonial domination were called the born frees, and the born frees mean, you were not part of the struggle for independence and the certain privileges that brings with it. And I think of myself as born free in the context of CRS. I came to UCLA when the program existed, and as a result, there are ways of being in my work that were the privilege of the struggles that Cheryl and the founders had all fought. And for that, I am eternally grateful. And what I want to talk about is that, to start with, but then also to talk about the responsibilities of the born free generation and that free, you soon realize actually is not really free. It's just it's a battle on different terms. So I am an international lawyer, and international law is not the original site of CRT, and I would say that international law was not necessarily a central preoccupation of the institutionalization of the CRS program. Here, correct me if I'm wrong, that is my own sense. But notwithstanding those facts, I would say that the CRS program and its institutionalization of critical race theory as an approach to thinking about law and kind of training lawyers and faculty to make sense of law in this way, to my mind, has had a tremendous impact on the field of international law and even on the UN system. I'm not saying that the CRS program rules the world or has transformed all of the world. I'm saying that there's meaningful influence, and I want to talk about that. As LaToya mentioned, I was a part of the Promise Institute, and the founding faculty director of the Promise Institute, Asla Badi, is in here, and those of you who know Asla know that she could and should be on this panel. And the two of us are actually on a panel where we will go into a lot of detail about Promise, its relationship with CRS, and for those of you who are interested in the project that we were able to, and Asla led this work, that we were able to do to think through how racism, and international law are mutually constituted. That project was anchored within Promise as a result of CRS, and I won't go into that because we will be talking about that on the panel, so you better come to that panel. This is me advertising for that one. What I want to talk about, though, is the impact, as I see it, of having an institutionalized space for critical race theory and the impact that it had on the work that I did in my UN mandate, which I'll say a little bit about in a second. So I want to think about going, if the theme of the panel is from theory to program, I want to think about from theory to program to praxis, because that was my own experience. And so in 2017, I was appointed to the role of UN Special Rapporteur on Contemporary Forms of Racism, Xenophobia, Racism, Racial Discrimination, Xenophobia, and Related Intolerance, which is basically being an independent expert within the UN system on those themes to UN member states. there's a whole story about how that could even be possible, which is itself a story about CRS, but I'm not going to turn this into an autobiographical, and then they did this for me, and they did this for me, because there's that version. I will set that aside, and I want to say, I want to talk more about the impact of being a faculty member at this institution and being part of the CRS program, the tremendous effect it had on the work that I did in the mandate, not only on my own, with students, some of whom are in this room, which is truly amazing, they're now attorneys in the world, but also with people I had never taught, but who had been trained here and were in countries outside of the US, who were mobilizing the knowledge and the kind of skills that they had developed in this building across borders. That's what I want to talk about a little bit. So the UN mandates, the special procedures mandates, which is what they're called, are severely under-resourced. And what happens is you, as the person in the role, has to rely on civil society and other ways to be able to move your work forward. Racial justice, racial equality has historically been deeply marginalized within the kind of international human rights advocacy space, which meant that there were very few civil society organizations operating internationally that were prioritizing racial justice and using the kind of lens that CRT brings to make sense of international law. And the reasons for that marginalization at the international level, I think, are analogous or related to the reasons for that marginality, even within domestic law. As a result, I found that much of what I was relying on, substantively, in terms of kind of the sort of doctrinal moves in the international space that I was hoping to make in my thematic reports, were actually best shored up and kind of found their foundation in the scholarship of critical race theorists. So, you know, reports on global extractivism, on reparations, on all of these topics, insights like insights of Professor Cheryl Harris and many other scholars who have worked to shift our understanding of colorblindness, to name it and address it. That work became doctrinally material to making arguments in the international level, in part because colorblindness is a liberal move that is transnational, right? And the dehistoricization and the depoliticization of race are transnational phenomena as well. And international law, in many ways, reproduces precisely the same kinds of productive blind spots that CRT has been invested in disrupting at the international level. We can have a conversation about sort of how the international, I think, has come back to shift, make moves within CRT as well, but I won't go into that because of time. But it's just to mark that substantively, in terms of the kinds of methods and tools and ways of understanding the law that I know I was able to rely on in my work, came out of being surrounded by people who were producing that knowledge and being able to work with students who were taking CRS courses, taking CRT courses, and bringing that kind of theoretical sophistication to the doctrinal side of international human rights law. And I think that it's part of why the Promise Institute for Human Rights, its trajectory, has been instrumental in making certain shifts, which Asla and I will talk more about on our panel. I want to say something about lawyers outside of the US, some of whom are in this room. I see Diana, who's from Colombia. I see Ohini, who's from South Africa. I point to them because in each of their cases, for example, my very first trip as special rapporteur was to Colombia, to an inter-American system convening, where I was stunned at just the powerhouse of knowledge production around human rights of movements that were there. And I was not surprised to find that the lawyers who were a part of those movements, many of whom were trained right here in this building, again, through the CRS program because of the transnational links that had taken place. So again, I highlight that to say that, you know, we can have a conversation about what the institutionalization of CRS meant for the domestic landscape, but I think there is an analysis that is transnational, that is urgent, that should be marked, and that part of the backlash, which is a transnational backlash, is a product, I think, of the reach of critical race theory, in part through the institutionalization that has been anchored here. And again, I'm not trying to overclaim and say that everything that's happened with respect to racial justice globally is a product of this program. It's just to say that institutionalization means that there is a stable place, resources for people to come together, think together, work together, and do work that is typically under-resourced, that is people are typically doing in silos because of the costs that are associated with that work. Now, of course, the work is not done, and the work will never be perfect, and as I mentioned, I am a born free, and I think now, for my generation, we are really coming to grips with exactly what that means, and it is something truly, truly terrifying. And I think I was watching actually the video on the founding of CRS, and Laura, you say in that video that CRS was born out of crisis, and that was actually incredibly comforting to me, because this, to me, this crisis feels singular, but maybe that just speaks to what I've lived through, It feels singular, and it strikes me that this is a moment for kind of refounding, returning to those kinds of questions and thinking about where we go. It strikes me that the liberal international order is imploding, in part because of illiberal threats, but also because of many things, including liberal commitments to racial parameters for self-determination. This is something I think that critical race theorists have tried to grapple with domestically, and I think it's something that international lawyers are grappling with internationally, the racial parameters of liberal commitments. And I think we see this in many places, perhaps most dramatically in Israel's genocide against Palestinians. And I think it is no surprise that many of these themes that are the tip of the spear of undoing and making harder so much of the work that many of the people in this room have been doing. It's no surprise that these things are being lumped together. So I think about movements that are fractured. I think about people and bodies that are exhausted. And I think about a time and a space like this as one for us to think about what needs to be born and what needs to be done differently, and how we build off of the amazing, amazing gift that we were given by the founders of this program. So that's probably longer than I was going to speak, but it's just an expression of profound gratitude, actually, for having been born free.
Thank you. I want to turn it now to Emmanuel. So Emmanuel, I wanted to ask you, really thinking about being a student here and then coming back and being a fellow, and now doing the work that you were doing after being a student, then becoming a fellow, now becoming a professor. What has CRS done for you through these different parts of your legal life?
Thank you. I'm going to just echo, it is an honor to be here as everyone's speaking, looking around the room and just like pausing to smile on the different faces that I see. Getting tapped on the shoulder as you're giving someone a hug to give somebody else a hug. That's been my experience here. So it's an honor to be here on this panel among two people that were my professors, amongst people that were instrumental in how I thought about law, critical approaches to the law, and then also had my back on the market, LaToya, I'm looking at you, that made it possible for me to enter the profession as well. So the theme of this panel is from theory to program, and that captures something essential about what CRS has provided for so many of us, I think. And that's the intellectual project of critical race theory made real, right? It is where the theory never stays on the page. So my introduction to critical race theory didn't start, like many people's, through the abstract of an article or through a citation in a footnote, but through a set of relationships, through a set of commitments, and through structural investment of the CRS program. And it's these kinds of investments that I think make ways of theorizing, teaching, and practicing law critically natural for us who came through the CRS program. Right? In this way, CRS has provided a space where race theory, critical race theory, was always a collective commitment, where its ideas and insights will always be inseparable to me. From the classmates that I struggled with together, I see you, Caleb, in the back there, to apply its lessons, to develop its tools, and to reclaim, I think, the broader pedagogical terrain of this law school and the legal landscape as a whole. So like many here, I imagine my path to law school was not preordained. Growing up, I never considered becoming a lawyer. as my undergraduate degree in fine arts painting and finger poke tattoos on my hands might suggest. I had no lawyers in my family. I had no lawyers that were family friends. The only lawyer that I'd had any real extended conversation with was a public defender that I had once when I was charged with a crime I did not commit. And so I only began considering law school really as a possibility after spending a few years organizing and protesting against police violence and always coming up across legal questions that I didn't have the answers to. So I knew that the law was something that I'd had to contest, but I wasn't sure exactly how. So what drove charging decisions? What constrained investigations into police departments? What exactly is this qualified immunity thing that I keep hearing about? With the hubris of an art student, I thought, I can do this. And so I started studying for the LSAT after work, and then I took the test, and I went to one of those law school information fairs in New York City, and immediately felt out of place. Almost immediately thought, oh, I've made a huge mistake. I don't know that this is what I want to do. But I did come across Dean Schwartz at the table for UCLA, and when I started talking about the reasons why I wanted to go to law school, he immediately handed me a fee waiver and said, you need to apply to CRS. And so I went home, I began researching it, I filled out my application to UCLA, and it was the first one that I sent out, and it was the first one that responded to me. So the deadline happened, I think it was December 25th or something, the deadline happened, and then January 3rd I got a call from Dean Schwartz saying, hey, you're in, you're going to be a student at UCLA. In the CRS program, I found, I skipped over something maybe important, I don't know. When I arrived here, however, CRS was not my first touch point. So it was the rest of the law school program, which I honestly found bewildering. It felt very detached from the reasons that I had come to school in the first place. And I almost immediately got caught up in the sorts of questions a lot of my peers were asking about, well, what are your grades? What are your LSAT scores? Where are you going to go intern? What kind of big law program are you thinking about? And I hadn't considered any of these things as important before arriving. But then I went to the CRS dinner the first year, and finally I felt like I found my people. I had a room of 20 people that were all here for the same reasons I was, who all articulated a passion and a drive to be in law school, not because they wanted to be rich attorneys, but because they wanted to change something fundamental about the world, and that drove them to come. In the CRS program, I found a very different grammar of law. Professors like Cheryl Harris, like Devon Carbado, made it possible to speak race in a school and in a position that often silenced it, right? My peers, who continued theorizing after class and in late night sessions, also taught me the critique was always a collective endeavor. I didn't know how to write theory yet, but I did learn how to inhabit it first, right? After graduating, I practiced at the intersections of national security and policing work, contexts that are known to resist critical sensibilities, especially those regarding race. And there, critical race theory became less about an abstraction and more about survival, about finding analytic clarity in bureaucratic opacity, and tracing how legal logics of suspicion and risk were reproducing these racial boundaries under the signs of security. It was my experience at CRS and the continued community that it provided for me in my peers and mentors that gave me the fortitude to remain steadfast in my commitments. I wasn't pulling punches in the work or taking the easy professional or political choices that might make that work palatable. And that's not because I was particularly brave or courageous, and not because the work that I was situated in was at the most critical or immediate juncture, but rather because I understood my relationship to this space to be a reciprocal one, right? It provided me with the critical tools to make sense of the law, and then in my turn, it was my responsibility to put them to use. I had a supervisor who told me, after I critiqued the racializing nature of policing in a public forum, that he had never met a lawyer with less sense of self-preservation. honestly, I took it as a compliment. I took it as a compliment, and I thought, well, you've also never hired a CRS grad. When I returned to UCLA as a CRS fellow, those experiences then turned back into theory, right? So Tendai was talking about from theory to program to praxis, and then it turns right back into theory again, right? And so I had the extraordinary privilege of teaching race, sexuality in the law, Latinas in the law here, and being in dialogue with faculty who treated me not like a student returning, but as a developing scholar with something to contribute, right? During that period, I developed the idea of legal endearment, a theory of how white affective attachments to policing, built across symbolic, experiential, structural, and social domains, operate as invisible barriers to transformational change. And it was a theory I could not have developed anywhere else, because the work grew out of conversations with the people in this program, with my students, and it provided the intellectual depth, the precision, and the rigorous attention to race as an actual site of academic intellect or intellectual investment that's really hard to find anywhere else. Unlike that earlier supervisor, my colleagues also never foregrounded concerns over my self-preservation, never suggesting that a theoretical, cross-disciplinary, and possibly maybe triggering article about white people loving police might not be the smartest thing to go on the teaching market with. They helped me to be strategic about the register at which I delivered the project, and they prepared me for the backlash that I was certain to face, but their investment in my success was not predicated on molding me and altering my work to become a palatable race and the law scholar. It was about ensuring that I could be the best critical legal academic that I could be. It's the kind of intellectual risk-taking that was possible only because of CRS. The fellowship wasn't just a postdoc that you could get anywhere else. It was a space of belonging that treated emerging scholars as co-authors in this ongoing theoretical project. I'm a little stuffed up, excuse me.
Coming from Minnesota.
You know, as some of you know, when I first got invited to speak on this panel, I thought it was a bit of a fluke, like I'd slipped through the cracks somehow, and somebody got mistaken, and here I am against intellectual giants, you know. But I realized that what felt like chance was actually just the result of their investments, right? It's their intellectual investments, their political investments, and their material investments. So people in this community have read my drafts before they were publishable, and they gave me feedback. They've written letters that have changed the trajectory of my career. And maybe most importantly of all, they modeled what it means to take each other's ideas seriously. And that's what the CRS program has done. It turns theory into infrastructure, right? And then that infrastructure provides a space for further theorizing. It teaches us that critique is not only analytic, but institutional. It's about building spaces where critique and we all can thrive. And the CRS program is not just a program in the sense of a cohort, a curriculum, a symposium, where material labor of creating that infrastructure plays out, but it's a program, to borrow from Fred Moten and Stefano Harney, that's in but not of the university, right? It's drawing the resistance into the university in which it is seated. In that sense, critical race studies is also a deprogramming space. It's a continuously seditious act against the notion of self-preservation, or excuse me, against the notion that self-preservation is better than collective liberation, right? So, excuse me again. Now at Minnesota Law, I teach property. I think we all teach property, which is a funny
It's wild.
I teach
Except
property.
me.
Yeah, well, yeah. Yeah, I mean,
But you wrote
taught.
a whole article.
I teach property, constitutional and criminal procedure, critical race theory, and critical theories of policing. And I'm constantly aware that my classroom is, in some ways, a small extension of this space, right? There have been many times over the past 2 years when I'm preparing for class or responding to a committee email on a question of faculty governance, and I quite literally sit there and ask myself, what would Devon Carbado do? And it's not just wear a turtleneck and a suit on a panel. What would Cheryl do? What would Tendai do? What would Kesu do? What would anybody else in this room do? And so although we don't have a critical race studies program at Minnesota or a concentration or academic center, we are building a community across the doctrinal and clinical faculty with staff and with students with whom questions of race, power, political economy, and communal struggle are the central animating commitments that bring us into the building each day. And so as I look to the next 25 years of CRS, I keep thinking about this recursive motion, right? From theory to program to theory. And I think about how the next generation of students, those who are now sitting in the classrooms in which many of us are teaching, and maybe wondering if they belong, will take these frameworks that I learned and we built and push them even further into questions we haven't dared yet ask, and into the urgency of this moment that I think needs them more than ever. And then I also think about gratitude. Not the sentimental kind of gratitude, although there is that, but the kind that recognizes how intellectual lineage is also a political commitment. That none of us got here alone, right? And the work continues because people carve out that room and hold it for each other. And looking around the room, I really do recognize the exponential effect that those commitments have gotten us. So thank you. Thank you all.
Thank you. And last, but of course not least, Kesu. So as a very serious and prolific scholar of property using CRT methods, I'm wondering if you can talk a little bit about what does that mean for your teaching? How is it that you bring that into the classroom?
Thanks, LaToya. First, let me just say, can everybody hear me? I always have to ask this. Pull this closer. How's that?
Yes.
Okay, great. My students know I ask this at the beginning of every class. It's always an issue. It is such a joy and an honor to be here tonight. It is not often you're in a room this full of old friends and dear colleagues and many of my students. This is a very rare gathering, and I'm so happy to be here. As LaToya mentioned at the beginning, I came to legal academia through this program. I was a fellow in the CRS program before I got my first job, and then I came back as faculty a couple of years ago. I research and write about the history of colonization and enslavement and how those projects shaped American property law and the real estate system that we have today. And I just want to say a little bit about what my experience was like before I came here, to offer some perspective on what it means to me to be able to do this work here as a fellow and then also now. When I started doing this research, I was a graduate student, I was a law student and a graduate student elsewhere. Asking these questions, especially in a field of private law, made me seem very esoteric. I would start to say what I did if somebody asked me what my work was about, and then their eyes, they would glaze over. They would felt that they misheard me. They would ask me why. They would encourage me to do something more relevant and useful that might actually get me a job. And just for perspective, because things have changed really fast and we might forget. I mean, I remember as a graduate student in 2011 being at a History of Capitalism conference in New York City, and there was a whole room full of people and a panel full of experts who all agreed, contra Eric Williams's work 50 years prior, that capitalism had nothing to do with the slave trade, that the slave trade was a different phenomenon entirely, and everyone was in agreement. And I remember leaving with another grad student. Thank you. We were just dumbfounded. You know, I think we cried. We were just so shocked that that could happen. And you know, I think we were right to pat ourselves on the back a little bit. Over the next few years, a stream of really astounding literature was published that changed how people understand that question, and I don't think it would be possible to make that claim today, at least not in that space, maybe in some of the new spaces that are being created by the Project 1776 and so on, but not in that space. It's not possible anymore. Even then, if I told people I was working on the history of colonization, they were baffled about why I would want to do this. They would start to make guesses about my own background, family background, as to maybe you're interested in these questions because you have a personal connection. And I said, my personal connection is living here on this land, and this is the history of this land, and these are the systems we have now. That wasn't really possible for people to cognize, really, or even listen to or carry on the conversation. It was a real conversation stopper, I'll just say, until 2016, when the events at Standing Rock drew the attention of the nation. And I would say it was in the years after that, it had been brewing, but it was in the years after that that the entire national conversation about our history as a nation, about the histories of colonization and enslavement, really changed quite fast. I say this all to say that I feel like this perspective, after this experience, I was convinced I would never be an academic. I would never teach, that there was no place for me, certainly in a law school, maybe somewhere outside of a law school, and I went to become a lawyer. From being a lawyer out in El Paso, Texas, Trump came into office, and the funding of my organization was threatened, and I had to look for other things to do, and I applied to this program, and then I became a fellow here. And I say this all to say that, from my perspective, the space for me to be able to be in the academy at all, let alone teaching at a law school, that possibility feels very, very recent, and part of it is due to the fast-changing national conversation about the history of this country. But also, it is really difficult to imagine how I would have found an entry point into the academy without this program. It was the first time I encountered legal scholars who understood what I was trying to do and could offer feedback to help me do it, who were hungry for those kinds of questions and excited to see the different ways that it would contribute to conversations they were already having about race and law and legal institutions. It has been this, I think, for many scholars and many students and many faculty, a home from which to ask and pursue the kinds of questions that it is really difficult to ask elsewhere, and the resources that are available. This is slow work. You need space, you need resources, you need time, and you need a community, as everyone else on this panel has already said. And so the Critical Race Studies program was that for me. It is a space that has incubated all of the different directions that critical race studies and the study of race and law more broadly must go. You only need to take a glance at the program to see how varied and rich the conversation has become. And the places it has to go, from my perspective, are all parts of the study of law. My own work has taught me that the reality of race in a country founded on the premise of racial hierarchy has profoundly shaped the law in every single subject that is studied in law schools today. And also the systematic erasure of questions of race has also taken place in every subject that is studied in law schools today. So that I think is what we are doing now. I think that is where the conversation has moved, and in large part it is due to critical race studies and to this program, which has grounded that field of study. No scholarship has theorized and conveyed the fact and consequences of that erasure and shown us the possibilities of other kinds of narratives about law more powerfully than critical race theorists. There's a couple of points I want to make in relation to that one. First about this program here, and then LaToya's actual question that she asked me about property. But to start with this program whose quarter century we're celebrating here, I really don't believe that progress is linear or inevitable. Cheryl talked about how lucky we are to have this program at all, and it's something we never take for granted, but maybe it's because I work on an arc of history that covers several centuries, but I do believe in the power of the truth. Messy and contested and plural, sure, but there are things that happened, and there are people now who are trying to say they didn't happen, who've been saying that for a long time, but I do think there are incontestable truths about this system and how it developed and how we got here, and the distortion of that history has been, as you all know, I think in this room here, a powerful tool of white supremacy. And this program has been a home for breaking those illusions, for providing other perspectives and analyses, for offering excluded data to the study of law, the training of lawyers, excavating alternative histories that actually reflect our many communities and intertwined experiences on this land. And this program, to foster that in legal education so that people who go off to become lawyers and work in the system and build systems in the future, shaping them with these ideas, I think we have seen the fruits of that. I think that is precisely the reason for the kind of pushback, blowback, and repression that we're seeing now. This program has been a really big deal in grounding all of that transformation and work over the last 25 years. And I just want to go back to something I said a little earlier, which is that, well, did I say it? I mean, the idea that race has fundamentally shaped American law and legal institutions is not a new argument at all. People have been making this argument since they were fighting to be free. You see it in the writings, historical writings of advocates going back over centuries. And even if you look in this century, you see, though, that these ideas did not make it into the legal academy for a century, if we're counting from the beginning of modern legal education in the 1880s. Every time there was a demand, every time there was a breakthrough, there was a backlash. And first that was directed violently against the individual scholars who dared to research these questions despite all of the discouragement and repression that they faced when entering the academy. Some people managed to put their ideas out and were marginalized and ridiculed. The CRS movement in the 1980s was the first to create an actual literature dedicated to these arguments in legal scholarship that were brought into the legal academy and the training of lawyers. That was led by Professor Crenshaw of our program when she was a student in the 1980s. And of course, as Cheryl also mentioned, I just want to also emphasize the importance of students, their role in creating this change. It was also a student movement that created the program here, this actual institutional home for these arguments, the first, I think still maybe the only, to foster research and scholarship in this vein in 2000. Now, there are many people in this room who can speak to the periods of backlash that followed each one of these gains. And I consider that I came into the academy on another wave of widespread demand because of changing national conversations and the students and the public and many faculty. And that was a bigger demand, I think, than we have seen in the past from the public at large. And here we are in a backlash again. And so I just want to say on a hopeful note that across all of this time, there has been a steady building of knowledge, a steady growth, a steady spread of the kinds of questions we're asking and the fields we're asking them in. These fields are transformed and they're not going back to the way that they were before. Tendai talked about international law, but I would also say that's true of the private law fields, the space of law and tech, even law and economic scholarship. Again, I think this program has been a really important base for all of that transformation. Do I have time to talk about property? I have a minute. Maybe I'll take two. The last point I want to make is also pretty hopeful. In that perspective, the gains we've made, especially the institutional ones, are pretty recent. And breaking into to every single field in a law school, that's something that is still ongoing. And I think what we need to understand about that is that we still have so much more to learn. In some ways, we're just at the beginning of asking these questions. On the one hand, the point is very old, right? This history of racial violence is fundamental to the founding of this country and the building of the institutions. But on the other, there is so much about these institutions and these practices and these laws that we don't understand because the resources have never been dedicated to researching them. And that I see, when I look around this room and I see my colleagues, I really understand the work that they're doing in this vein, helping us understand more about the things that we've taken for granted, about the things that we were taught one way, but in fact can be shown to be entirely different. And so now really finally to LaToya's question, I teach property law, and when I began to do my research, I was really astonished by the things that we didn't seem to know. I was really completely shocked. I felt like completely gaslighted by my own experience of reading, to see all the history that I was seeing about the origin of certain institutions, and seeing that my colleagues in property law understood all these institutions to merely be received and somewhat adapted from England. It's just completely false. The fundamental institutions that create this land system were colonial inventions, a comprehensive survey, a public registry system, easy and routine foreclosure. They were designed by colonists in order to expropriate tribal nations' land, in order to keep track of property and expropriated land and enslaved people. This is a fundamental history about endogenous development on this continent of a property law system that has also spawned the biggest speculative real estate market on the globe. So there is a lot to learn. I'm still trying to learn it, and I consider that to be our collective project here. Again, because of the long arc of the work that I do, I know that we're going to continue to do this. I know that we're going to continue learning more about all of our fields, and I'm so grateful to be in this with all of you.
So we thought that we'd spend this last about 10 minutes or so taking any questions or comments from the audience. We have somebody here who's going to be able to pass around the mic. So, yes.
Hi, I have a very simple question for Professor Harris. You mentioned an article in Mother Jones. Could you say that once again?
That is a great question. And let me see if I can find the name of it again. The author's name is, pardon? Pima Levy. And it's about the dual state. She cites the scholar that in the post-World War II re-examination of the Nazi period first developed this idea.
Other questions, comments?
I love a question I can actually answer.
Yeah. Claudia, she's already back there.
Thanks, y'all. That was brilliant, as expected. Question for you. I think, Tenda, you were the one who mentioned that CRS was created out of crisis. So the question is for the entire panel. We're in crisis now. What are we imagining might need to be invented or that we need to create in order to rise to the occasion?
I'll take a stab at that. I mean, there was a Race and Law Center gathering that happened earlier today. And one of the things that we talked about was to say, well, you know, there was a Project 2025. Where's Project 2029? And that's what I think we need to start building. We need to start really thinking hard about what is it that we want to be building towards when, hopefully, this is over. In the back.
Would you like us to all respond, or is that?
Go ahead. Mm-hmm.
So I was going to just say, so that's a quote from Laura Gómez. So I want to just attribute it to her. Mm-hmm. The CRS was founded in crisis, which I think makes it even more powerful. But I know that from the perspective of thinking about transnational racial justice, which to my mind, if you look at where we are now, to my mind, it's continuous with, say, 2020, right? I see this block of political kind of explosion is kind of in communication with each other. And so I've been thinking a lot about what it takes and what it means to build transnational racial justice movements that can survive or that can reconnect even when they're under siege in the ways that they are now. And so I'm trying to think about how we attend to the fractures right, within the transnational racial justice movement, fractures that we could talk about in different kinds of ways. But that's the question I'm thinking about. How do we build power? How do we connect under circumstances that are tailored to destroy the spaces where that typically takes place, right? So that's very granular, but I know it's where my mind is.
I don't have a big round answer to that, but I do think the fact that CRS, this program, was born out of crisis reflects the fact that instability creates opportunity. And we're in really unstable times right now. And I think my memories of the last time we all went through this, not that it's the same, but my memories of the last time were being so amazed at the people who rose up to take advantage of the opportunity. People who had been working on something their whole lives with no expectation that they would be able to make an offering to everybody and show us the way on something. And so I think that's kind of how it's going to go again, you know. We can't predict the shifts that are going to happen or the ruptures that are going to produce these opportunities, but I think the thing is for each of us to be ready and to support the people who are rising up in those spaces.
Buenas noches. My name is Camilo. My question is a bit about the generations that I see coming, maybe we're becoming, in some of this advocacy. I've struggled trying to integrate the law protest, organizing with legal advocacy, and frankly, if I were to mention Antonio Gramsci, maybe my students or faculty would think it's a fancy restaurant somewhere. So I see the people before us moving on, not just the interregnum that was mentioned, but some of our elders becoming ancestors. And I feel that weight, that heavy pressure of not just carrying the torch for those that had it lit before us, but that perhaps, certainly our law schools, I have no question that they don't really care as much. I'm sure they're listening. But sometimes even our own, the younger generations maybe are not as attuned to feeling it. That image up there on the screen, I see it as being our campus, being the Supreme Court as well. And I struggle with that 25 years. Are we swinging the pendulum all the way back to someday bring back more change, or is it going to fall off the clock? And I know there's many of us here are experts in this, trying to weave this transition, but I say that as somebody who wants to carry that torch and wonders if no one will receive it on the other side. Thank you.
I'll say that I don't doubt that quoting Gramsci per se is not necessarily the way into a conversation with a 22-year-old. But the basic insight, which is language trying to name the place where we are, whether we put it in terms that, you know, harken back to an early 20th century theorist, or whether we put it in terms of the blues, the same insight, which is the idea of occupying a place of contradiction. I think young people feel that immensely. And wherever there is that space, it's an opportunity for us to listen as much as it is for us to talk. That's hard for me to say, for anybody that knows me. But it means that part of what I think we have to develop is our listening skills. The sort of field is designed to turn young people into nihilists. It's designed to make them give up. And one of the things that I think is always a part of any human at any age is the desire for hope. So I try to take that forward in the sense of not presuming that there is any one thing that's going to necessarily connect with a person. But I do feel like if we think about this as developing a culture, not just a practice, that one of the things that we can do is to find space, right? This is very interesting to me to be talking about having conversations with young people because I don't have a social media account. I don't. I kept thinking I was going to get one, and then each platform that came along got played out. And so, I was going to get a Facebook account, and then that got played out, and then something else came, and then, Musk bought Twitter. I mean, every time I got ready to sign up, something happened. So it wasn't like it was a big political commitment. It was just sort of so I have to find my place of connectivity in not so much talking, but in listening, and in listening for the questions, because that, for me, is actually how I learned. Much of what I learned, I did not learn in formal school. Much of the reading, I didn't read Gramsci in college. Do you know what I'm saying? So the point I'm trying to make is, I think we all have these tools, and I think young people are hungry. So it's just a question of finding an opportunity and a space to create, to listen for the questions.
If I could just add just a little, I do have old teenagers, right? And one of the things that I think is most important for them, I showed it in my class, a video of Derrick Bell, and someone asked him, well, this just sounds so bad. How do you have any hope about any of this? Mm-hmm. And what he said was that hope comes from truth, that you can't hope unless you know the truth of where it is that you are. And I think it is our job right now to teach our young people the truth. And that's why so many of these anti-CRT, anti-DEI, taking our experiences out of the K through 12 curriculum, that's something we really need to be fighting back against, because it's not teaching our children the truth. And it's only through truth. I actually believe this wholeheartedly. It is only when we know the truth can we really say where we can go. And that's what gives me hope, in telling the truth.
If I could also just jump in and say that, I think I spent a lot of my life thinking about living up to my elders, and that's the way I thought about how I motivate, how I, sharpen myself and kind of be the best version of I can be in this work. And I've actually stopped doing that. I still respect my elders, and so it's not a disrespect. But what I find myself trying to do is to live up to my students, right? And to live up to the students, because I think that there is something about this generation of students that is unwilling to accept the kinds of stories or ways of being in the law that I know I accepted and didn't even dare question. And that makes me feel so fortunate to be a law professor. Again, I focus on international issues, and when I say visiting encampments, protesting in encampments across campuses, not only in the US, in Europe, in South Africa, and speaking to students and getting a sense of their understanding of that conflict, for example. Or I'm thinking about the racial justice uprisings and having conversations with students who were active in that period and hearing the analyses that they had and what they wanted to hear more of. The number of students who've asked me about capitalism, I never said that word in law school, I don't think. I mean, my professors could maybe come and tell me that I did. It's just to say that, to my mind, I think the challenge is to live up to our students, and the attacks on campuses and on students, and the disciplining of law students, I would say the structural kind of disciplining of law students to say, we will check to see what you are saying if you're going to get a job here, to my mind speaks to their potential and the urgency of doing that. So I think what I'm sitting with now is, how do I live up to the students, and how do I create institutional space to continue to learn from them? And this is not to say that they are perfect in the same way that faculty are not perfect. There's things we can do to better serve them and vice versa, but it's just to say that I actually have the most hope when I'm most closely connected with my students.
Just to jump on the first part of your question, which was, I believe, struggling how to integrate organizing, law, all of these different things that are important to the students, but not necessarily reaching them with the language of the academy. I teach CRT, and I taught race, reform, and retrenchment yesterday. And we were talking about this question of, okay, well, the intervention that Kimberlé Crenshaw makes there is that the law is a site of re-legitimizing inequality and projecting neutrality on these questions. But the type of destabilizing that we're seeing now is not happening in law. In fact, it's a rejection of the legitimacy of all forms of institutions. So law or education, social institutions, political institutions. And so I said, so what does the reform look like there? And the students sat for a while with that. And then they said, well, I guess that we have to destabilize all of these other sites as well. As Kesu said, moments of crisis are moments of opportunity. That doesn't mean it's just opportunity for us. It's opportunity for anybody that wants to seize the moment. And so, one of the things that I was left with Crenshaw's article, she says we don't struggle in law because law is the site of our liberation. We struggle here because it is a site of power. You know, it's a site of power, but so is all these other spaces. And so one of the things that law school, as Tendai was saying, does is discipline students, but it also disciplines them into believing everything is a legal problem. Yeah. And so what I tell my students is like, you weren't just a lawyer before you showed up, and you don't need to show up just as a lawyer after you leave. And so if you want to organize, organize. If you want to be in political community and do that, do that. And if you want to resolve legal problems, then resolve them with the tools that you have here. But don't believe that this toolkit, just because you have a hammer now, everything is a nail. You have this, the attack is on all fronts, and you need to show up on all fronts, and not necessarily as a lawyer. You know, and so that's how I think about responding to the students that want to organize. I say, why not? You know, and that I think that can be freeing. They think that they're becoming a lawyer, and that's the only opportunity forward.
Okay, so do you want to say anything?
I'm all right.
All right. We are actually at time, so please let us thank all of our panelists.